stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome back to Administrative Static. We are joined by our colleague here at the New Civil Liberties Alliance, Senior Litigation Counsel, Greg Dolan. Greg, you're making a habit of appearing on the program. Welcome back.
I keep getting invited. Blame you.
Well, you keep bringing interesting cases, and the one that we're going to talk about today is one that I think has gotten surprisingly less national attention than I would have thought. Not so much that the case has gotten less attention because it's a brand new case, but the Consumer Product Safety Commission has approved a draconian new magnet safety standard for non-toy products, which broadly bans high-powered hobby magnets for adults. And yet, this has not hardly been noticed by the mainstream media, but it has been noticed by you and those of us here at the New Civil Liberties Alliance. And you have some concerns about what the Consumer Product Safety Commission is doing here. Tell us about your lawsuit.
Well, perhaps the reason it didn't get noticed so widely is because Consumer Product Safety Commission, and I'll get into it as well a bit later, has been doing so many crazy things for the last few months that it's hard to catch them all. But as to this suit, this is actually the second time the Commission has tried to ban these sort of magnets. They were slapped down by the 10th Circuit once before in 2016, I believe. And the 10th Circuit told them that you are the way you're doing your studies and the data you relied on is bad. It's not scientifically valid. And
I think you told me that panel had then Judge Gorsuch was on the panel in the 10th Circuit that struck down the first time.
Yes, so he was in a majority. It was a 2-1 decision. He didn't write the decision, but he joined it. And it was a fairly narrow decision in that it didn't get into all of the claims brought by the plaintiffs. That because he said, look, we don't need to discuss why you're right 10 times. It's enough to say no, right once. Right. But the CPSC went back to, I want to say they went back to the drawing board, but they didn't. They just simply kind of waved their arms around a lot and said, well, here's a new rule, much like the old rule, slightly narrower, but not much.
Right. And you're filing suit in the same jurisdiction again?
Well, filing suit in the same jurisdiction, we made sure to say that although there's no pending related case, we made sure to put it right front and center that it was previously before the 10th Circuit, and the 10th Circuit told CPSC once that they're wrong, and they should do so again.
So let's say a little bit more about what exactly this ban covers to the extent that you can, and we're not going to go into tremendous detail, but people may wonder if magnets that they have or that want to purchase might be covered by this.
Sure. So the ban covers all sorts of high-powered magnets of all shapes, as long as they're smaller than a particular size, as defined in federal regulations.
And anything above a certain flux capacity, right?
And anything above certain flux capacity, but even that is, we didn't really get into that in our brief, but even that is a little weird because the flux capacity is meant to measure the attractive force of the magnet. And there is a sort of one-to-one correspondence of the magnets of the right shape. So if it's a spherical magnet, the higher the flux capacity, the higher the attractive force. But if it's weirdly shaped, if it's kind of like zigzaggy thing, then the flux capacity could be one thing without necessarily having a high attractive force. But we sort of let that issue go. So it's basically highly attractive magnets, sometimes known as rare earth magnets, that are of too small of a size. Basically, the idea is that kids will stuff them into their mouths or nose or ears, and there'll be problems as a result.
And no one wants to see children injured by ingesting magnets or button batteries or anything else. But I'm not sure that the answer is banning magnets. And we have knives, hot stoves, lots of things that are products intended for adults that are dangerous when kids get a hold of them. Why is the CPSC banning this product? Why is that the reaction here?
I mean, I imagine everybody who's listening to this podcast at one point or another had their mother tell them, don't run with scissors, right? Precisely because scissors are useful but could be dangerous if mishandled. And you're right. Nobody wants to see kids, swallowing things that they're not supposed to swallow. But a couple of things. One is that there are methods of preventing, such as, packaging, safety warning. So, and perhaps, when, for example, look, I just got a new niece less than a month ago.
Congratulations.
Thank you. And I know that in anticipation of that, my sister and brother-in-law, they baby-proof the house, as most people do. And they'll do it more when she starts crawling. They'll plug in the outlet plugs and things like that. So, yes, when the adults have small children at home, they should be, the making should come with a warning that, they should be stored properly away from kids. And there are voluntary standards. And in fact, one of our clients tried to promote more voluntary standards precisely along those lines. But these magnets serve useful functions outside of being swallowed by children.
Right.
So they can be used to model, for example, DNA when you study how that functions. It can be used to model three-dimensional protein structure. It can be used to model all sorts of things. And sometimes they're good for stress relief as well.
Sure. Well, and in the hobby space, they're used as latches for different kinds of things. I mean, if you're building cabinetry or anything like that.
They're used for that. They're used, for example, for people who build like model toy cars to attach kind of the body of the car to the chassis. So there's wide application. These are not just kind of...
Right, like trains. A lot of times there's magnets in it.
Exactly.
Hobby trains.
So they're not just kind of just random small spherical balls like rolling around.
Right. And so tell us about what your particular claims are in the suit. And one of them I want to get into kind of goes beyond the scope of this particular rule, which I know you have concerns with, but you have concern with the structure of the agency as well. Maybe we should start there.
Correct. And so, like I said, the advantage of being CSPC is promulgating so many crazy rules that it's hard to catch every single one of them. And that is why this brief reiterates the position we've taken now a number of times, mostly as amici, but now as a party. The CSPC, the commission, is unconstitutionally structured. This is so-called independent commission. It's not quite, it's a bizarre structure. Even like the name independent commission is a bizarre structure, because independent of who? And usually I want my government to be dependent on my approval as a voter. I want to be able to vote out people that I don't like. But this commission is not responsible to me as an elector, not responsible to Congress, it's not responsible to the president. The president can't fire these people.
Yeah, I've been on my high horse about this for a while, because for the first basically 10 months of the last administration, the Trump administration, 3 of the 5 commissioners at the CPSC were still Democrat appointees. So you had this quote unquote independent agency doing things that the president of the United States never would have supported, but they were doing it within the context of the executive branch. That can't be constitutional.
Right. I mean, it would be fine if there were 3 Democrats that Donald Trump decided to keep on, but they stayed on not because Donald Trump chose to keep them on, but because they were not easily removable. And so, I'm always leery when people say independent, we want more independence. I'm like, well, independence or cool. Even judiciary is not independent. They're independent in each given case, but as new president and new senators come in, we get to appoint more people, etc.
Yeah, absolutely. And then, so there's this precedent called Humphrey's Executor that way back in the 1930s, the Supreme Court said that these sort of independent agencies were okay because, at least the one that they looked at, the FTC, they said, well, it's quasi-legislative and quasi-judicial, so it's not really doing executive power, outside the president's authority. But this looks a lot like executive power. I mean, you're banning a product that feels awfully executive to me.
Well, let me begin by saying I think Humphrey's Executor was wrongly decided, even on its own set of facts. I don't think there's such a thing as quasi-executive and quasi-judiciary. You're either executive or you're judiciary or legislative, or one of the 3.
Yeah, it's a quasi decision.
Right, exactly. I mean, it's one thing if Congress wants to create a body, for example, like U.S. Civil Rights Commission. It just goes around, writes reports. They don't have any specific authority. That could be fine, right? But this body has executive authority. They can ban a product. They can prohibit importation of certain things into the country. So they're kind of guarding the borders, essentially.
Yeah.
Which is...
They're product cops.
Right. They're traditionally executive function. And so what we argued in the brief is that, on one hand, Humphrey Executive was wrongly decided. But even if it wasn't, if you look at the actual language of the decision that says, look, they're kind of quasi-legislative, they write reports, they be quasi-judicial, they may have judicial adjunct functions, but they don't execute the laws. And I think Congress has taken that decision and taken it way beyond its own norms and said, well, if we can keep quasi-judicial and quasi-legislative, maybe we can get fully executive as well. And so what we argue that either the court should overrule Humphreys, which of course the 10th Circuit cannot do as an inferior court, but it can of course tee it up for the Supreme Court. But even if it follows Humphreys to the letter, but you can't just follow Humphreys like the first paragraph, but not the third paragraph. Following the decision.
Right.
And if they follow Humphreys, then they have to say that Humphreys never blessed an independent executive agency, which is what CPSC is, and therefore it's not properly structured.
That's right. So, the agency itself, its structure is at stake in this decision, not just the magnet ban, and hopefully the 10th Circuit will reach that. Back to the ban for a minute. I mean, one of the things that you say in here that struck me is the agency, after the last ban, put together a bunch of data to try to justify this new ban, and it said, look, the ingestion level of magnets is way up after getting rid of our last ban and saying it was unlawful. But you point out that, well, ingestion of all small items went up, not just magnets.
Exactly. And it's not, we don't necessarily know why that is. Maybe part of the data overlaps with COVID, and so when there's like more kids at home, and we know that when people were isolated, they were maybe not as attentive because
stir crazy,
maybe they were having a bit too much wine after dinner and they were not watching it. I don't know. So maybe part of it is that. Maybe part of it is we generally are more lax at labeling, but you can't pick out one fact and ignore the larger data into deciding on what the rule is.
No, that's exactly right. So the rule is irrational. The agency is unconstitutionally structured. All kinds of problems here in the case. And if I didn't say it at the top, this is magnetsafety.org v. CPSC. We'll count on you to keep us posted on this case as it goes along, Brett. Thanks for being with us.
Thank you.
Welcome back to Administrative Static, and Mark and I are thrilled. We have Devin Westhill, president of the Center for Equal Opportunity. New president still, I think I can say.
Yeah, somewhat new.
Yeah, exactly. And it's great to have you here. And we're going to talk about a case that was argued in October of 2022 for the Supreme Court. Two cases, really. And we have not seen any opinions. And I have a feeling we'll see the opinion on the last day of the term. It's going to be my other prediction I make on this program that can be thrown back in my face later. But then welcome.
Thank you.
And tell us, you just told me that you were at the oral arguments, or you were listening to them?
Well, first of all, let me say I'm really happy to be here with you. I really respect NCLA. I love the organization. The Center for Equal Opportunity that I run as president and general counsel has worked with NCLA on at least one other. I like that title, by the way.
Project nobody has. It's a good one, isn't it?
And so I'm really pleased to be on your podcast. So this is great. I was not at oral argument. I can't remember why I wasn't. I think it was probably some family matter. Otherwise, I would have been there. But no, I listened in, which was a nice option. I listened in from my home office in Jacksonville, Florida for 5 hours as Harvard and UNC were argued.
And so we've talked about, I believe we've talked about these cases before, but these are cases, one against Harvard and one against North Carolina, saying that their affirmative action programs are racially discriminatory and therefore cannot be allowed under the civil rights laws and maybe under the Constitution. But one is a private university, being Harvard, and one is a government university, being North Carolina, where our scores of fact checkers and researchers that we have here at the NCLA Administrative podcast, found out you went to North Carolina.
That's true. That's true. Yeah. So it's these cases are both professional interest to me, but also a personal interest for various reasons. I run an organization that is interested in advancing and promoting colorblind, equal opportunity vision of this country, both in the public sphere and in the private sphere. So we're interested in this sort of thing, and we do a lot of work on it. But personally, I am an alumnus of the University of North Carolina. I'm also racially and ethnically diverse. I'm half black, half white, to whatever degree those things make any sense, and dividing myself up that way. My wife is half Vietnamese, half white. Our children are just a combination of all sorts of things, and so this is especially sort of interesting to me. I oftentimes say one of the worst things about the race preferences in college admissions and other spheres of life as well is that people live with a potentially a stigma for the rest of their lives, an asterisk on their resume for no other reason than they were born minority or favor.
Justice Thomas speaks about this quite a bit. Now, so how are these? So the court upheld affirmative action programs almost 25 years ago. It said they'd fade out 25 years. What were the
lower courts did here too?
Yeah, exactly. They both lower courts. They found. Now, I think the Harvard case, they said, there's no discrimination, which I think is clear error right there. But they said it was allowable, I think. Well, what were your arguments, and what are the arguments that affirmative action is not allowed under the law?
Well, I could go into a whole lot of things. So CEO was involved in no fewer than 5 amicus briefs in these cases. They're pretty important to us. At the certiorari stage, we joined with the Pacific Legal Foundation, an organization we've worked with for a long period of time. CEO is almost 30 years old, almost as old as the Pacific Legal Foundation, in urging the court to take the cases. One of our senior legal fellows, Stuart Taylor, filed a separate brief as well with UCLA professor Rick Sander. Both of them literally wrote the book on mismatch, for example. So 2 of those, and then 3 at the merits stage. What we filed with the Pacific Legal Foundation was a brief saying, look, Grutter, the case from 25 years ago that you mentioned, that basically sanctioned the use of race preferences for the purported benefits that flow from a diverse student body, but only for 25 years. Well, in dicta, right? The whole idea of the 25 years is that in dicta, the author of the opinion, the Grutter opinion, Justice O'Connor, suggested that 25 years, maybe race preferences won't be necessary for the diversity rationale. But we wrote that it was grievously wrong the day it was decided. It is wrong not only in terms of violating our civil rights laws, Title VI in particular, which says that schools that get federal funding cannot discriminate on the basis of race or other characteristics and activities or programs and so forth. But also the Equal Protection Clause of the 14th Amendment prohibits this. And those 2 things are coextensive as well. So while that's primarily targeted at the UNC case as a public institution, whatever the court says on Title VI is very likely to be construed as being identical under the Equal Protection Clause of the 14th Amendment as well. So we said, look, on the day it was decided, it was wrong. But also, there's a whole lot of evidence that's built up over the course of almost, as you suggested, 25 years now, that suggests that it's actually really, there are no benefits. If there are benefits, the benefits pale in comparison to the problems that are created by race preferences.
And in our vast body of fact checkers did find out that many states have passed laws against this. Even California, I guess some people would call them blue states, have passed by referendum or statute that these preferences are not allowed in their schools. And I was amazed at how many of them there are. And I guess that also is maybe new to the court from this time, and they have some evidence from there.
That is a good point, and that continues to grow. I think Arkansas was the most recent state to outlaw race preferences, and it's public contracting, public college admissions, and so forth. But I don't know the exact number. We're up to a good maybe dozen or more states that have done that. What happened with at least California is instructive as well. It's very interesting to kind of look at, given what advocates of race preferences say, right? The argument basically is, look, we have to do this because if we didn't, campuses would be lily white, and we wouldn't get that really great benefit of whatever those.
Although in these cases, it's Asian students who say that they're being discriminated against, right?
Well, they're white adjacent. You have to understand.
Okay, all right. I'm not up on all this stuff.
Well, neither am I. But and I thought that is one of the comments that gets made. But what happened when California outlawed race preferences, Prop 209, was that we saw at the University of California, Berkeley, the composition of racial minorities and the admitted classes did go down. But what happened was the composition of racial minorities and sort of, the other UC...
the next tier.
Privileges, the next tier down, if you want to call it that, UC San Bernardino and, other colleges in UC system, saw the racial minority composition of students increase. And what was also apparent after studying this for a period of time was that those racial minorities were much more likely to graduate on time.
Which is so important.
Critically important, right? I mean, you don't want to just be admitted to a school. You want to graduate from it. You also want to stay within the major potentially that you plan to study. And in the hard sciences, at least, the evidence suggests that racial minorities who get these really massive preferences change their majors to softer majors like sociology and so forth. And that it seems to suggest that, but for these sorts of racial preferences that are pretty big in some cases, there would be more black and brown doctors, more black and brown engineers, more black and brown lawyers, for good or for ill.
I'm sure you meant the lawyers, but in any event. So we have a couple of minutes. So I'm going to ask a harder question. This is what's bugging me. So because the court has interpreted the statute, Title VI, before, there's a huge preference on the court never to change statutory rulings that they've made, so that even people who think it's really wrongly decided won't change a statute, because Congress could do it, right? Congress could change Title VI tomorrow. So there's this huge built-in resistance to changing any interpretation of a statute. Does that mean, but there's also the idea that you always interpret a statute so as not to violate the Constitution. So these two things are in tension. Do they have to go to the Constitution if, in other words, because of those canons, are they going to go with changing their interpretation of a statute, or are they going to go directly to the Constitution and say not allowed under the Constitution?
I don't know. But that is a good sort of explanation of some of the challenges that the court is dealing with, I think, when it comes to these cases. The court, I think, there are individuals on the court who care much less about some of the canons that you just laid out, such as, the heightened stare decisis, requirements for overturning statutory decisions, because, as you suggested, the Congress could speak to this, and will be willing to do what I think it ought to do, which is just say what the law is, be deferential, right, to the fact that no one's perfect, not everyone knows everything, all these sorts of things that cut in favor of stare decisis. But at the end of the day, especially on an issue of the magnitude of racial discrimination in this particular country, we have got to actually get it right this time around.
Yeah, and I think they will, but like you, I don't know how they will either, because of what I just said. I do not think, we were saying before, it's not going to be 9-0. We're going to see some talk between the justices on this one. Thanks so much for coming.
Thank you very much. Great to be with you guys.